Good evening. This is Laws 12062 Alternative Dispute Resolution. It's week 9 and we're dealing tonight with Spencer's Chapter 8, which is lawyers and legal issues. It covers, in the current edition, pages 221 to 258. I'm going to provide my overview. As usual, I invite your comments and questions, either directly or through the chat facility. I expect that my commentary will only be 15 to 20 minutes at most. And the reason for the relative brevity is that effectively what is contained in this material is non-examinable, but I still would like you to know it, of course. And when we've completed the task, I'd like to speak to you in relation to the assessment issues, and in particular to have your thoughts in relation to the technology and whether you see any impediments to having your assessment put through on time. So firstly, Chapter Spencer 8, there is the question of confidentiality. Confidentiality, of course, is the hallmark of mediation, and it's necessary that parties feel safe and secure in the ability to make offers and negotiate freely. There is comment made in the text, which hopefully is very rarely an issue, and that is where parties try to introduce material which is perhaps against their interests, but introduce it deliberately in an ADR context so that it can't be disclosed in a hearing. One way that I deal with that type of issue is to make it clear that as far as I'm concerned in terms of confidentiality, it relates not to everything which is said in the process, but rather those things which can be properly categorised as attempts at negotiation or compromise settlement. So therefore, in my view, evidence which is introduced would not be the subject of confidentiality, but there are some cases and some commentary, and I'd invite you to read that and perhaps take a break should you find yourself in a position where you are a mediator and you're confronted with that situation. There are some statutory exemptions to allow disclosure of confidential information from time to time. That is, for example, to enforce an agreement, to provide evidence to counter something which is otherwise going to mislead the court, to provide information which might be relevant to the question of costs, and that's referred to in your text. There are instances where without prejudice privilege can be overridden by the general law, and without prejudice is a term which is used very often by lawyers, and strictly it should only apply in circumstances where there is essentially a written communication which is intended to assist the parties in resolving the issue. So, for example, an offer to settle would be without prejudice and headed without prejudice, meaning that it can't be raised in court at a later time. So the concept of without prejudice is very similar to the concept of confidentiality in relation to communications made during a mediation session. And in the book, Spencer makes some comment in relation to when those without prejudice privileges which are claimed can be overridden, and that is where the parties are engaging in misleading or deceptive conduct, where the communication which purports to be without prejudice in fact creates a contract, where the communication prevents a court being misled, that's an exemption to the general rule, where the communication itself constitutes criminal conduct or tortious conduct, or where the communication said to be without prejudice is in reality nothing to do with settlement negotiations, and the case referred to in the commentary is Field against Commissioner for Railways. So the point you can take from that is simply this, that you might head something without prejudice, but that doesn't necessarily mean at law it is without prejudice and cannot be raised in communication. And they're the exemptions that I've run through. I'll leave you to read the commentary and flesh that out. Again, if there's any questions as I proceed, please feel free to stop me, interrupt, and by all means use the chat facility. Privilege. Legal professional privilege is claimed in relation to certain things which are essentially communications between the lawyer and the client, but not necessarily all communications. Those communications brought into existence for the dominant purpose of existing or contemplated legal proceedings. So that's what we refer to as legal professional privilege. In other words, those communications cannot be raised in court. They're out of the realm of the court's evidentiary purview. Margaret?
John, can I just ask a question about that notion of Chinese walls within practice, where you may have people in a law practice representing the two different parties, and then the mechanisms that they do set up so that there isn't any chance of information, confidential information or privilege being breached. So would that apply? That would come in under this as well?
Yes, that's a great question. It certainly could. The Chinese wall concept is where you have parties being represented by lawyers who happen to be within the same firm or within the same organisation. You can imagine that for some organisations, such as the Legal Aid Office of Queensland, that's a tremendous issue and one that needs to be taken very seriously. Certainly the same rule applies in private practice, in law firms. That needs to be taken very carefully and proceed cautiously. The safe rule, of course, is don't do it. Generally speaking, in almost all circumstances, there's no reason why practitioners should be opposing each other if they're within the same firm. But the Chinese wall concept is very real. You tend to find it in conveyancing a little, and that is where one solicitor or a conveyancer might be representing a buyer, the other the seller. The penalty for doing that, of course, is that firstly you need to make very clear disclosure to both parties. That may discourage one or both parties from proceeding further with your services. And secondly, if things go wrong, you'll be heavily penalised by the compulsory insurance excess payment which needs to be made, and it's a huge amount, I think $15,000 or $20,000 or so. So yes, those rules do apply, Margaret, in relation to the Chinese wall situation, but generally the advice is avoid it unless you really have no alternative. But thank you. So we're talking about privilege. We're talking about those things which cannot be raised in open court because of the privilege which attaches to the communication. Another is contractual confidentiality, and that requires the court to consider the agreement. For commercial clients, it's likely to be strictly construed, and the decision of ESO Australia Resources against Plowman, High Court 1995, is an example where the High Court was not prepared to imply a term of confidentiality in relation to information disclosed during an arbitration. That's the second type of privilege, contractual. The third is statutory privilege, and there's some reference to that, for example, in the Civil Procedure Act of 2011. I should note that the text is a little out of date. It still refers at times to the Supreme Court Act. That, of course, has been superseded by the Civil Procedure Act. All right, so that's all the comment that I wish to make on privilege. If there's no questions or comments, I'll move on to liability and immunity. An ADR practitioner could be sued over procedural issues, not likely to be sued over substantive issues associated with the dispute. So there is a potential liability of a mediator, for example, and that liability may arise as a result of a breach of contract or a breach of torts, for example, negligence. In terms of establishing that there was a breach of tortious liability, there are the usual things that need to be established, and that is that the mediator owed a duty of care, that the mediator breached that duty of care, that there was actual loss or damage suffered by that party, and there was a causal connection between the alleged negligence and the loss. So they're just the basic rules of negligence. There is, however, something very important to consider, and that is that in many instances where a mediator is involved, there is a statutory immunity. And in that regard, I'd ask you to refer to the Civil Proceedings Act once again. To my knowledge, I'm not personally aware of any situation where a mediator has been sued, but it's possible that the mediator could be sued for failure to comply with procedural requirements. Enforceability of settlement agreements. The law of contract applies. the settlement agreement, and I'm talking usually in the context of mediation, but the same can apply to conciliation or any form of ADR. That agreement can be structured as a contract between the parties. It can be a deed of agreement between the parties, or, and this is quite common, it can be a consent order of the parties. You're probably all familiar with the difference between contract and deed from your studies in contract law, but in a contract, of course, amongst other things, we need consideration and we need intention to create legal relations. For a deed of agreement, we don't need those components. And just looking to see a question coming in. Could a mediator or other ADR practitioner not be sued for fraudulent misrepresentation? Yes, that's quite possible as well. So a fraud might be another instance where a mediator could be sued. One would hope that would never occur, but potentially it could. And that fraud might occur in circumstances, thinking on the cuff, off the cuff, is where the mediator has had a prior relationship, particularly a commercial relationship, with one of the parties, and that was not disclosed. Enforceability of dispute resolution clauses. As you would have seen in the commentary, it's very usual in a commercial contract to impose upon the parties, or have it as part of the agreement between the parties, a clause to say that any disputes must be referred to alternate dispute resolution. And there are a number of rules that relate to that. Firstly, some commentary in relation to Scott and Avery clauses, and that is the parties may agree by contract to involve in dispute resolution as a precondition to litigation. And there's nothing wrong with that. That can be enforceable, but it needs to be done with certainty, which is the second thing referred to in the commentary. And if you read all of that commentary in the text, perhaps you may or may not agree with me where I say that I glean from that provided a court can determine the meaning of a dispute resolution clause, it will be held to be valid and enforceable. There have been some divergences of opinion, and in the commentary Spencer makes reference to cases in New South Wales, Victoria, and in the federal jurisdiction. He commences with those cases which adopt the hardline approach, starting with Elizabeth Bay Developments against Boral Building Services. Now, this was in 1995. And in that case, the court considered an ADR clause which was detailed, made reference to two external documents which were not annexed to the contract. The external documents were held to be inconsistent with each other and the clause, and the guidelines for the appointment agreement did not create sufficient certainty in the process, held the court. So the parties had agreed on mediation in the contract without agreeing to its terms, and in that instance, the agreement to agree was held to be unenforceable. So in that instance, the clause requiring the parties to attend ADR as a precondition to court, essentially the Scott and Avery clause, was held to be uncertain and therefore unenforceable. That hardline approach was also mirrored in the 1999 decision of Alton Australia against Transfield, where the mediation clause was found to be uncertain as the mechanism for appointment of the mediator's costs was not sufficiently established. And in that case, the court probably fairly, and this is quite a hardline approach, determined that that clause which was uncertain could not be severed from the overall negotiation clause, and as a result, the ADR clause itself was struck out as being uncertain. Now, I take it you know what I mean by severing that clause. If you have a clause that may have 5 or 6 different parts to it, it may be that the court will adopt the attitude of saying, well, 5 of those 6 can stay. The one which is uncertain will be severed from that clause and not be regarded as it. The alternative is to say the whole clause has to go, or the whole contract has to go, and that hardline approach was adopted in the Alton case. So the parties do have the opportunity to set out in some detail the procedures and the ADR clause and the process in a contract in order to evidence the requisite intent to be bound. So that's what they need to do. And more lately, the moderate course has been adopted by courts, starting with the 2000 decision of computer share and perpetual registrars, where the court found that the agreement to negotiate was capable of being enforced. The parties had shown a clear intention that they agreed to participate, even though the prescribed process had not been yet identified. It's almost as if it was regarded by the courts as better not to make an attempt to describe the process, which was uncertain, and just leave it for the parties to agree at a later time. And that line of thinking, the more moderate approach, was approved in 2009 in United Group Rail Services against Rail Corporation, where the clause specifically dealing with mediation was held to be valid, and it was also held that the clause requiring the parties to negotiate in good faith was also valid and not uncertain. In the previous cases, another reason that the courts struck out the clause was because they regarded this term for the parties to negotiate in good faith as being uncertain. And in United Group Rail Services, the court held that that type of phrase is not uncertain and can be enforced. So what do we glean from all of that? At the moment, in the absence of any High Court decision to tell us otherwise, Spencer's view, which I think is right, is that the courts do appear to be more willing to acknowledge that the nature of dispute resolution, which gives parties freedom to resolve the dispute the way they see fit, cannot be expressed with great certainty in a contract, and as a result, the courts will tolerate some degree of uncertainty in that process. But the final comment that I'll make is this, that the clause relating to ADR in a contract should have some remedy, should provide for some remedy for breach. That is, if a party refuses to comply with the terms of the dispute resolution clause, what happens? One remedy is that the other party, the aggrieved party, is entitled to damages. That might be including the costs of legal matters. Or the second is that the party might be entitled to an order for specific performance. Specific performance is an equitable remedy. You'll remember that from your introduction to law days. And equity and specific performance is essentially an order of the court forcing or compelling a party to proceed with the agreement as should have taken place. So we often see specific performance in the context of real estate transactions, where a seller refuses to proceed with the sale of land and the court orders that the seller is compelled to do so and specifically perform the contract. So there are problems associated with both those remedies in terms of compelling a party to comply with the ADR clause in a contract. Unless there's any questions, and I know that's quite brief, but for the reasons I've stated, I wanted to keep it brief, we can move on. While you're thinking if there's any questions, if you have any questions you wish to raise, can I just draw your attention to the fact that you are now able to have your say. That's all through Moodle. I think at this stage it's only one person has had their say. It's all anonymous, and I'd encourage you to do that. It helps the university in terms of the feedback, and it certainly helps me to have feedback as well. So I would encourage you to do that. All right, so are there any questions in relation to Spencer's chapter number 8, dealing with legal issues? Okay, let's move on to the second part, and that is I'm very keen to have your thoughts in relation to the assessment regime from a practical perspective, and in particular to ask how you're going with dealing with the audio-visual aspects of this course. Now, as you're thinking of your questions or raising any issues that you may wish to, or maybe providing some solutions that you've come up with, I just go back to the initial stage of this course and indicate that by its nature, ADR to me is a hands-on course. It's less theoretical than practical. And if I had my way, we'd all be in a big room and we'd be doing a workshop for a day, actually practicing mediation sessions and practicing the way in which we go about ADR procedures in real context. But we're doing the next best thing we can, certainly given the nature of the online course. I think it's appropriate that we have the audio visuals. I know it's not for everyone, and it does require a bit of acting skills, but can I say what I've seen so far in terms of the presentations of mediations have been really good. They've been excellent. Now, question coming in. Catherine said, when tried before, the sound died and couldn't hear a thing. That may have been my fault, Catherine, because I muted the microphone. In your instance, your mediator's opening statement is 4 minutes 10 seconds long, and I think that's plenty long enough. If you've covered what you need to cover, then that's fine. So thank you for doing that. Do we need a live audience to present the opening to, says Margaret? That's a good question. No, you don't. By all means, you can have a live audience if you wish, and they can be on camera, if you can work the camera to include them, or they can be off camera. But I suspect that most people, as has been the case already, will simply have a dummy audience, make-believe audience, and that's what I expect will happen. Is anyone having any difficulty in actually uploading through Zoom to YouTube and then across to me? People have been able to do it so far. What they do is they send me an email. You can send it to me at johnm1492@hotmail.com.au or the university email address, and I'll have a look at the link. You may have to invite me, if it's a private YouTube channel, you may have to invite me to have a look at that particular transmission. But the ones that have been coming through are good. Yes, John?
Oh, hello, John. Look, I was just going to say that for contract law, no, not for contract law, for torts, I had to do a presentation. And when I uploaded it to YouTube quite easily, but when the processing occurred, it took all night. And then eventually it failed. And then I tried again, and it kind of just happened before my eyes. So sometimes I was just going to say you do encounter a few little problems in the processing, not actually in the uploading.
Yes, yes.
And I'd also like to say, in terms of how you were saying, if you had your way, we could all get together in a room. I agree that'd be a really good idea. But I'm also finding, just with the presentation I did on Zoom, how real it was, how I really felt like I was addressing the judge in the court, and how good these forums really are to give you that feeling of really being there.
Oh, that's great. Thanks for that feedback, John. And it's meant to be a bit of fun too. We don't want anyone to freak out over it and take it too seriously, because mediation is meant to be something which is a little uplifting and empowering for the participants. So you don't want to be too dour. You want to be a bit friendly, and the ones that I've seen coming through are great so far in that regard. If you really can't face the idea of having it audio visual, I will accept it as audio only, but my preference is audio visual. And I think you can upload directly from Zoom to Moodle, but you may have some difficulties in terms of the upload procedure. If you go through YouTube, it generally would be much easier to do. But I hear what you're saying, John, and there are the issues, technical issues as well. Cheryl, is it possible to use someone not an ADR partner to be a partner for recording the session for emotive questions, and we then take the emotion out of the answers, as it is the answers taking away the emotion that is really important? Yes, look, provided I can appropriately consider the assessment, then you don't necessarily have to have an ADR partner, provided there is the, and you're talking no doubt about assessment number 6, provided I can see the exchange, that will be sufficient. The idea of pairing you up was so that it's more efficient. You both have a scenario and you can collaborate a bit more. But if you don't wish to partner up and you wish to have someone who's not an ADR partner, then that's okay as well. Does that answer your question, Cheryl? Anyone have any comments about what I've just said? As you can tell, the main thing from my perspective is being able to view your work, and how we actually logistically do that. I'm flexible. All right. So we have now for the assessment, which was to be submitted on the 1st of September, which is yesterday, almost everyone has submitted. The ones that I've checked so far are very good, high quality, so thank you very much. By next Monday, the 8th of September, everyone should have uploaded their Zoom session, which is the mock mediation session, the introductory statement, as a mediator, not as a participant. I hope that you all picked up on that. And the upload, hopefully through Zoom, via YouTube, and get that to me somehow. Send me an email, johnm1492@hotmail.com.au. Then we have a series of rolling assignments. We have the 30% written assessment due Monday the 15th, and then the 2 final assessments due on the 22nd of September. That is the group discussion, where you are contributing for the assessment that's written, and then of course the 10% Zoom session in pairs. The reason for the last one is only 10% is that in case there were some real difficulties and people couldn't get that done, they have at least the knowledge of knowing they can still pass the examination or pass the subject. All right, but it's still an important one, and I do hope that you have some fun with it. Okay, are there any questions then before we wrap up for tonight? Okay, and thank you for your comments, John Curtis. All right, well, we might wrap up for tonight. Please use Moodle, exchange ideas. If you've found something has been successful, then kudos to you if you're willing to provide some guidance to fellow students who may be struggling, particularly with the technology. And if you could upload some hints or some thoughts through Moodle or through emails, I'm sure they'll appreciate it. All right, well, I'll stop recording now, and thank you very much for your attendance.